Yes, we'll be back from the break. Still watching the Smart Men's Business. I'm Anji Ubariji, and definitely in line with the discussion today of the beneficial ownership law, of course, which is in a way of streamlining when it comes to benefits, who actually benefits when when the company transacts with its suppliers, customers, and third party, who really actually benefits. It's been observed that in a 2020 report, Africa the illicit financial flow worth 328 trillion. That is, if you're to put it in Ugandan context. And in 2020 alone, Uganda, money that was lost as a result of illicit financial flows went as far as 5.4 trillion. And of course, this is witnessed with massive corruption aspects, imbalances when it comes to trade invoices, and so many more aspects related to that. Now, African Union and the United Nations decided to come together in a partnership to see how they can actually formulate beneficial ownership registries. And now this cuts across for Uganda. Now, for this reason, I'm joined with David. He's from Transparency International Uganda is the programs officer. And with Charlotte from the Uganda Registration Services Bureau. She's a senior registration officer, and we're here to break down these matters. How can this be? How do we establish a working relationship? And actually, this segment is proudly brought to you by Transparency International Uganda to tell you. Now, a very good morning. Happy to have you.
Morning. Thank you for having us.
Thank you. Now, probably I wanted us to start with the flows. The report, 328 trillion. It's a lot of money. For Uganda's case, 5.4 trillion. How is this even happening? Are we scared to speak about certain things because we've seen this transpire in the oil sector? Big issue. we had so amazed by Heritage Gas and Oil shifting its company to Mauritius because they don't want to pay 1 trillion Ugandan shillings. How is that?
It's been a long discussion when it comes to issues of illicit financial flows.
Yes.
But for the viewers out there, good morning. It's a rainy and cold one.
Yeah.
So the challenges that come with such days is that then you look into your pockets and realize that there are certain perimeters probably you should have been ticking off. But by the time you're not ticking those perimeters, it shows that probably economically we are not doing well. So Transparency International Uganda, we are a national chapter of Transparency International. That's a global coalition against corruption. We're in over 100 countries all over, and our main mandate is on fighting corruption.
Okay.
However, for our discussion today, we entered into a partnership with Transparency International Kenya under a program on domestic resource mobilization.
Yes.
And there is a bigger program on financing for development. And this looks at how poor countries like ours, can look internal and strengthen systems and ensure, they develop, especially when it comes to economics. So in Uganda, we realize one of the key challenges, not only Uganda, but in most of the sub-Saharan countries in Africa. Most of our challenges relate to corruption, of course, issues of illicit financial flows. We have challenges when it comes to money laundering, issues of how our extractive sectors are being exploited, and what that benefit, that countries receive from most of our mineral wealth. And it came to the conclusion that one of our key problems is that, we have a lot of corporate opaqueness. So when we have that opaqueness within corporate bodies, it then becomes hard to track, the monies. But the thing is that when you want to track the money, you have to track the person behind the money. So now the current discussion on beneficial ownership that brings us here today is that there's been that global outcry that it's time now we unveil, that person behind the money. So between 2018 to date, we've been having discussions on how to strengthen our beneficial ownership laws. And that also included redefining who our beneficial owner is. If you've been following discussions previously, a beneficial owner would be a company, that a company would own another company.
Yes.
But now we want to know the natural person. Who is that person? Behind, who is that natural person behind that company? So that even if you have 100 shell companies, now you're interested in knowing that individual, the natural person. So that's what brings us here today. So discussions of illicit financial flows, how we lose lots and lots of monies. Of course, now we want to summarize it in how then we can use beneficial ownership as a tool, to avoid such scenarios.
Wow. Charlotte, Senior Registration Officer, Uganda Registration Services Bureau, what's your take on the statistics when in relation to, illicit financial flows in your department as a registration officer?
Of course, the statistics are overwhelming, and it's about time we actually took up this and took it seriously and ensured we fight the anti-money laundering and fraud and all the illicit funds and movement of money, because at the end of the day, the country will suffer economically. So we need to make sure we ensure that Uganda actually goes off the grey list, and we put our country up there economically. It helps with funding, it will improve on the foreign investors. So this is a good step towards improving the economy, and we just hope we implement it and take it seriously, not just use this year or 1 year to actually implement and enforce, and then it dies down. No, we need to keep doing it and keep enforcing and implement strictly, because at the end of the day, it's our nation that will suffer. We'll lose out on so many opportunities economically.
Okay. Yeah. And maybe still on that, according to Accord Uganda, they believe that as ways of putting this into order, it comes in line with amendment of the Company Act. Is it in line with that?
Yes, the Companies Act was amended to implement to include beneficial ownership. Yes, and then also a law regulations, the company's beneficial owners regulations, also for partnerships.
Okay.
But this is strictly limited liability partnerships.
Okay.
So because they tend to have a form of corporate status like an entity. So the laws were amended, and we started enforcing them last year, 2023. And then also the different forms, because the regulations regulate how we implement and enforce these different laws in the Act. So the laws have been amended, and now we are enforcing everything. Yeah, as URSP.
Interesting. As we speak right now, what are the beneficial ownership? There was the formulation of the Anti-Money Laundering Act 2023. How effective has that been in combating, illicit financial flows? Because the tide seems to be too high.
The AMLA has actually been around since 2014. Since 2014, if I'm to be guided, 2013, 2014, the Anti-Money Laundering Act. And that mainly looks into aspects of money laundering and financing of terrorism. So discussions of course, beneficial ownership, it's more strengthening now the law, that where the weaknesses were, we are currently building up on that, because globally, this is not just for Africa, but globally, issues of terrorism financing is becoming a global problem.
A global problem, yes.
You look at organizations such as ISIS, Al-Shabaab, when you go to Congo and all this, it's currently a global challenge. Even when it comes to the Russia-Ukraine war,
yes,
you look at the role of the oligarchs, those super rich people, and their role in, financing, the war, and it becomes a challenge. So as a country, you need to put in place systems that can then, try to interrupt, that flow of illicit cash. So when it comes to money laundering, it doesn't stop at only the money that comes into the economy to finance other economic activities, but you also look at those other illicit activities such as terrorism. And Uganda, we've had, I think, in the previous years, we've seen, the role of ADF,
ADF, yeah,
in trying to distort peace within. So if we don't wholesomely, handle this, at some point it will catch up with each and every one of us.
Okay. Now, getting back to URSP, as part of, you are part of this partnership, how are we going to ensure this? Recently, there was something that happened about the URSP boss, of course, with the allegations of a corruption-related aspect. And how are we going to see that we balance, we put this right? If maybe, of course, I understand there is no perfect system, there is no perfect agency. These aspects are bound to happen. How would you look into executing this despite the few challenges we have internally?
I think that was UBOS.
Oh no, UBOS, sorry. I speak,
let me
sorry. UBOS, Immediate Services Bureau. Sorry about that. I mistook. I was mistaking UBOS with your. Okay, sometimes just keep.
Yeah.
But anyway, still back on URSP. Last year, you deregistered a number of companies for quite a few aspects, and I feel maybe did that deregistration have where such aspects looked into, like their transactions? Because I believe some of these companies were providing employment to the people, and I understand probably they weren't returning the anticipated amount of money for a given period of time, which is okay. But you get to realize that people anticipate that probably you could be aware of some of these people that are doing this, but that are doing the money laundering aspects. And yet the people who are scrapped off, they are deregistered, they have been deregistered, they have been actually contributing something to the economy. And these people that are non-touchables, they are putting the money out of the country.
First, I would like to correct with it's not deregistration, and as per the law, it's clearly stated out in the Companies Act. If a company does not, you're required as per the law to file annual returns every year. Basically, annual returns giving the status of the company in that year. If changes were made, you give the status. So if a company takes more than 5 years, five years above, without doing the same, because you're supposed to notify to show that you're actually active and you're operating. The law mandates or gives powers to the registrar to actually, it's called striking off.
It's not deregistration.
It's not deregistration.
But it's the report's saying deregistration.
Let me clarify and make sure the viewers understand the difference.
Exactly.
So when they say, when the law provides that we strike off that company. So when they strike you off, you're given a period of time to actually apply. You're notified.
Yes.
That's the notification we did in the newspaper, the newspaper of wide circulation. And then you're given an opportunity to explain why you shouldn't be deregistered. So many actually companies that were now not bothering to update their files were actually responding. Now that notified us that actually those companies still want to operate. So they applied and gave reasons. You know what? We still want to operate. And then what you're required to do, you file the annual returns. You have to comply up to date. And now when you do that, we remove it from the struck off list, and then now you can operate. If a company does not respond for a period of time, technically we assume they do not want to operate again. Now that's when the deregistration process starts. So it's a step, it's a procedure. We don't just deregister. You understand?
Okay.
Then, but also it's also a form to actually push. Because of the new beneficial ownership requirements, it was one of the administrative decisions we had to implement the law, because we are mandated to do it, to push companies to actually file beneficial ownership forms, to update their files, and to also clean up the register, because we're having so many companies in our register that are dormant. They're not doing anything. Imagine a company that has been incorporated in 1990 and up to now there's no activity on that company. So these are the things we're trying to clean up. Clean up the registrar, have proper information. Know, is this company operating? Is it active? If you're active, please be up to date. Provide the beneficial ownership information. And it has actually worked because we've collected a lot of information in that regard.
In that
So,
regard.
yes.
Wow, amazing. Now to David from now for on the side of Transparency International, there has been a great concern about capacity building that some of these organizations cannot even detect illicit flows. How do we see about that?
Conversations on illicit financial flows when it comes to sub-Saharan Africa and other LDCs, actually, it's a challenge because of just the nature of how we conduct business. I'll give you an example of Uganda. We are mainly a cash-based economy. So with a cash-based economy, it's very hard for a system to track that money is moving from point A
to
point B. But with advanced economies where you have most transactions going through financial systems, you can actually track that today, David has processed a transaction of, let's say, $1 million to a certain company. And then from that company, you're also able to track the final destination of the money. So when you operate in such a context, imagine you have an agency like a Financial Intelligence Authority. It's supposed to gather intelligence, but FIA has one office, that's the head office. But they have to gather intelligence in the entire Uganda. Now, going by the fact that we are a cash-based economy, it's very hard to reach all these areas. If it was using probably digital systems, it becomes easy. But also, the financing of these agencies is still lacking. You see, combating corruption and illicit financial flows, it's highly technical. It's highly technical. So you need the capacity of these agencies. You need them to be fully financed. You need them to be fully independent, but they also have to be almost on the ground, because when you rely on third-party information, sometimes you may not get information as credible as you'd want it to be. But then also, it shouldn't be just the role of now these agencies. How does the common citizen come in? We have a lot of aspects of apathy. You know, we always see, I'll give you an example of these high spenders that always see in town. Someone comes, flashes money, we praise them all the time. But we don't actually question their source and intention of that expenditure. So realize probably this is money coming from illicit sources. But guys are coming to spend it just to conceal. You know, when you look at money laundering, it has, you know, those various processes, and one of the processes you want to conceal, and then you want to integrate. So in that process, just the fact that you're spending carelessly means you're trying to, you know. So that apathy in citizens, you know, trying to glorify these individuals and, you know, not asking the right question, it also then, you know, it also waters down the entire efforts of, you know, combating illicit financial flows. Then the other one then will come to now the information, the availability of this information, and the role of the whistleblowers. When you look at the current beneficial ownership law, you know, it's mainly hinged on the fact that companies will disclose information. Then investigations will be conducted in the event that we are not satisfied that the real declared beneficial owners of that company are the actual beneficial owners. But then in case, you know, the relevant authorities that are supposed to then do the investigations don't actually pick interest in these cases, there should be the role of the citizens, you know, to flag up, to provide the red flags that, you know, as much as Andrew said he owns this, it's actually owned by David. But that has to come from the fact that this citizen who is whistleblowing has to tap in the given source of information. So where there is a lot of secrecy, where information is not readily available, it becomes hard. Now, in that event, that means even the investigation department may not do much. Because world over, most of the cases we've seen, at least most of them have been a result of leaks. You can go to the Panama Papers, Pandora, what, it's mainly the leaks. And this leak comes from me and you. Most of the leaks may not come from the government entities. So the fact that that access is not currently easily available,
Yes.
it becomes a problem.
Very interesting. With David from Transparency International Uganda is the programs officer. And Charlotte is the senior registration officer, that is Uganda Registration Services Bureau. And of course, in discussion with the beneficial ownership law, analyzing it and how helpful will it be in the coming years for this country, Uganda. Well, for now, let's take a short break. And of course, I'm still returning with this panel shortly after.
Smart 24, driving business. Smart 24, driving business.
Well, 27 minutes to the top of the Smart Men's Business. Amanju Babrije, and like I told you today, the discussion is in line with beneficial ownership law and seeing how it's going to be transformative to this country's economic growth and development. Of course, like I told you, I'm with David from Transparency International Uganda, Programs Officer, Charlotte, that is Senior Registration Officer, Uganda Registration Services Bureau, and now I'm joined with Blair. He's a lawyer from a law firm known as KTA. Now, on that, I'm going to start on the note of, because we're talking about disclosure of information. You need to know who owns this. And now there is the aspect of privacy. How are we looking into that balance?
Thank you so much, Andrew, and good morning, viewers. When we speak about beneficial ownership, just like my colleagues have already explained, you're dealing with disclosure of information. So for many Ugandans, this speaks into the sensitive information,
Exactly.
or even just the identifying information, which some would define fall under the privacy laws. And by that, we mean Article 27 of the Constitution, which provides for the right to privacy, but also referring to the Data Protection and Privacy Act, which is actually a complete law that is protecting your information from unlawful disclosure.
Exactly.
And the key term is unlawful
Disclosure.
or access to even that information illegally. So, and prior to actually having the regulations, like the senior officer from URSP mentioned, so the regulations that we have, the 2023 company beneficial owners regulations, came as a result of many concerns around whether you are breaching the right to privacy of individuals, because the beneficial owners sometimes will be individuals and other times may be companies.
Oh, yeah.
So when it is speaking to individuals and the information required sometimes is identification numbers, age, the location of these people, the professions, and some of that clearly identifying information. So prior to that, there was a big concern. And some of the people that struggled with this is the banks. So in fact, the Bankers Association in 2018 petitioned the Constitutional Court. So the petition was against the Attorney General, and the Attorney General and the Commissioner General of URA,
Yes.
who issued a notice to 30 banks and asked for, give me every information that you have on the accounts. I want to know who owns them. I want to know what the transactions are.
Exactly.
etc. So what the Bankers Association did through that petition is to allow the court to actually explain how the right to privacy comes in. Also to draw the nexus where beneficial ownership regulations would actually stand. So what they did, and the court clearly stated that you have your right to privacy. Beneficial ownership information is not going to take that privacy away from you. It just limited the powers of the Registrar General of URA to ask for specific account information. So the court's ruling was, if there is suspicion that there is something wrong going on in this account, they're saying that the annual turnover is 2 million, but we all know from what they're doing, clearly they're registering millions and billions of money. Then the Registrar General can go and cite out that, you see, we've done this investigation to this stage, and now what we need is to know the beneficial ownership of this company, or even what transactions happen. And that's where also our colleagues from Transparency International come in. And when that was done, it made it clear that you have your right to privacy, but where there is suspicion that what you may be doing is criminal in nature, the state actually can get access to your information. So when we have the regulations coming in 2023, one of the most important things that it does, actually this is the second last regulation for the penalty clause, it speaks to how the registrar will cooperate with all these institutions, government, that may need your information. So the registrar must cooperate, but is also given the power to limit what information is disclosed to these people. So what that did, it created a sense of security for your data. When you give your data to URSP, the regulations themselves pointed it out to the Registrar General that whereas we give you this information, you don't just disclose it anyhow. You have a level of disclosure that you extend to everyone who needs information. They must also be very clear what they need. So even when you go and file all your beneficial ownership and you give all these details to URSP, Transparency International is not going to come and say, give us everything on your register, unless they prove that everyone on the register is being investigated. For some kind of crime. So what they do is, you give the information to the state, it is guarded under serious sensitive laws, Privacy, Data Protection and Privacy Act, but where there's a suspicion of criminal element, then there is a degree of allowance for the registrar to lobby in and see that actually justice can be served. And that's how it helps. And the benefits are super immense.
Super immense. Well, there is something I'll compliment on that, but I think later on as we wind up. Now, I see something with the oil sector. There are constructions going on in oil constructions, I think, in Tilenga. And as I saw, about 25% of the contracts, which are worth $1.75 billion awarded. And it's bringing the stakeholders getting to understand who is actually benefiting from these contracts. Because oil is the next thing that we are looking up to. So what are we planning for it in terms of beneficial ownership? Because we are seeing scenarios where certain companies supply themselves, they inflate the prices, and it comes back to the common person. Oil in particular, now.
The oil industry, and generally the extractive industry, is one of the most sensitive industries, especially when it comes to beneficial ownership.
Exactly.
So the reason is very simple. For most of the investments in oil and gas, you're looking at foreign direct investment. So you're looking at foreigners who come and put their capital into the state. So for many people out there, see Uganda perhaps as an easy country to play around with. And what they do is they study the laws and they agree that, okay, with these laws, we can maneuver around here. That's why you see that the creations of things such as the beneficial ownership register or even the regulations themselves are recent developments. And oil was discovered over a decade ago. So what usually happens in this sector is something that is around transfer pricing. So I'll just briefly try to explain that. So the network of most companies is to say, what we'll do in Uganda is we'll set up a small company, and this company will be on ground and they'll be excavating. So then what we'll do is all the paperwork will be done from perhaps Mauritius. So then when that is done, the lead company will be incorporated in the Cayman Islands. So all these are actually offshore states,
yes,
where the tax regimes or where generally beneficial ownership and things like that do not exist. So what then would happen is you would have all transactions and deals negotiated between Mauritius and the Cayman Island, and then the work done here. So what that would deny URA is actually knowledge of what transactions happen in the Cayman Island, who owns
that, exactly,
or even sits in Mauritius. So what the beneficial ownership regulations bring on board is the requirement for the company established in Uganda to disclose that whereas the shareholders registered are A and B. For this case, I'll use Ntambi and Chisito. Those are the ones in Uganda. And they mine all these stones and metals, and they just see these metals, on boards and everything.
Exactly.
But the negotiations on who they're sold to are done between Mauritius and Cayman Island. Now you also have to put on the register the guys that are in the Cayman Islands, how they incorporated, who they are, and then also the guys in Mauritius. So when you have all that information, the country now can easily trace where there is what they call revenue leakage. That is principally the country losing taxes. So where there is taxes lost because business is done, but you don't see the money, you follow the trail of the money through the companies. So then you can actually tell that if there is money laundering, many of the times you will trace it back to Mauritius, the Cayman Islands, and then you will easily bring this company on ground to order, because it's actually what makes the money. So by all means, that network can be kind of managed through this new arrangement. So principally what it does is transparency in what businesses have to do in order to run themselves very smoothly and abiding by the existing rule of law.
But also to chip in into councils, just to bring the discussion home, is that initially with the shell arrangement of companies, it was very hard to tell who the real person is. Now you'd find that, I'll give an example, that a Ugandan goes and incorporates a company in Mauritius, but his residence and everything is within Uganda. So on one of the requirements on the BO register is you have to give your residence, your identification, and all those details. So why it is so is that, now currently in our double taxation agreements, we are trying to renegotiate that for someone to benefit from these DTAs, you have to be a natural resident with that jurisdiction. So not a Kenyan incorporating a company in Mauritius and coming to do business in Uganda, because it has happened before. There are cases within URA where it has been happening. That Kenyan goes the other side, incorporates, then comes here and does business. So by the fact that the beneficial owner is a Kenyan, you lose that benefit of enjoying the arrangements we have with the tax.
Now, interesting. Talking about what Council has mentioned, all these perspectives. But now it brings me back to recently when we survived being blacklisted on money laundering, and things are moving on well. So how are we protecting that status? Because we experienced it in the financial markets where we saw some offshore investors actually pulling out their money, not trillions of money. And how are we protecting that state of being a country that is of that? Of course, people were interviewed from the Ministry of Foreign Affairs from so many perspectives to really prove that there is not really such cases coming up. So how are we ensuring that the beneficial ownership law actually also protects us to that level? Because if you get onto the blacklist or any assumptions that something is not right, foreign direct investment is inevitable, and we need it. I think that I'll start with David on that.
I'll give my perspective, then maybe URSB will come in.
Exactly.
Because they've done a lot when it comes to ensuring that we are grey listed. However, from my side, I may say during the period, we've undertaken the second national risk assessment under the FIA. Of course, that looks at, I don't know if you read the report, but there is a long list of certain parameters they look into. For example, what are the current risks when it comes to money laundering? There are issues of accountable persons, like the role of the real estate, the lawyers like counsel here, and property brokers, and all. There is a long list of, and then ensuring whether we have now mechanisms and laws to ensure that they actually comply. And one of those is that we needed to strengthen how we red flag suspicious transactions. And I think it's happening currently. Is it 20 million above? If you have a transaction of about 20 million, the financial institution has to red flag it. And of course, it's a lengthy process. What we are seeing currently is, I think we are in the move to being, to getting off the grey list. However, it doesn't stop there.
Exactly.
There is still a lot of work that we need to do. And currently, I think our register of beneficial owners is still, at that stage where we are just starting. But of course, URSB will explain about the current penalties and how it has started biting. For example, if you have a company and you have a bank account and you haven't filed your beneficial owners, last year around December, we saw many companies crying that their accounts were locked. So that's being done. And it's one of those moves. Of course, when you're grey listed, it impacts negatively on the country. You can't freely transact, you can't freely attract investors, you can't freely access Forex. Yeah, so.
From Charlotte.
Basically, because as we know with this exercise, there are different accountable persons. So now, like the banks did their part, they closed accounts to force people now to come to URSB to actually file beneficial ownership information, and it's a continuous process. However, but also as accountable persons, we are required to have continuous reports. And assessments with FIA, because we always have meetings with FIA, and they give you reports. In this period, how many risks, how many companies have you noticed? There are red flags. So basically, the continuous engagements with FIA and reports that you have to give to FIA. So it has helped, it will help maintain the activity and to ensure that we comply, all companies comply with the beneficial ownership information. But I think it's not just about one entity. It's all of us. It's a chain. So like if a bank closes a company, they have to come to URSB and URSB does its part.
Okay.
If, for example, even people register as cooperative societies, they have to do their part. LLPs. So it's just a chain. It's not just about one entity. If one accountable person does its part, the people responsible have to come to the other accountable person. So it's one umbrella of activity from the different accountable persons.
Wow, interesting. I think we just left about a few minutes, but before we wind this up, back to Council, and in relation to what you mentioned about privacy laws. Now, the country China will look up to today it has just started actually to impose some of the labor laws, which we cry for so much here in Uganda. It poses a feeling that because if you go back to the the revolution where the Communist Party came into play, the aspect of law, there was a belief that if you're not economically stable and you're poor as economy, you have no right, because it is in a state. Not until you stabilize, then you have a right. I would feel that, is privacy really a big deal at a state where we are into turmoil and somebody really wants to keep their information private and the country is losing trillions? And as of 2020, it was 5.4. I don't know even what 2023, how much money was lost as illicit financial flows. I think at some point the law will operate at a certain level, depending on where you stand economically, and you're claiming a right to privacy. What do you think about that?
That's a good question. And the nexus between China and the democracy is going to be quite a long debate, because the Chinese system of meritocracy most of the time comes at the expense of things such as the rule of law. But it's a completely different system than the one that runs in Uganda, one of democracy, where power is actually given to the people. To determine how they are governed and ruled. And that's how actually you have a constitutional regime, which then gives people these rights. And actually the constitution doesn't give them the rights, just kind of enforces the position of a democratic ideal. That if you have information that is very seclusive to you, then at all costs, this should be done against unlawful disclosure. And even the right to privacy is a clear one. It's not what they call a non-derogable right. So what that means is, whereas you have the right, it can be taken away. For example, if you are a thief and you go and steal someone's money and you keep it in your house, you cannot claim the right to privacy in your house. When that's where the money of the other person is being hidden. So that's where actually police gets the search warrant to break into your house. And I'm using break with a lot of caution.
Yes.
To access your premises and retrieve what was stolen, what belongs to the other person. So it's the same context here, really. When you have information, it belongs to you. There's an entire legal regime that protects this information. The Constitution, Data Protection and Privacy Act of 2019, all these actually even cluster data. There is ordinary data, there is sensitive data. For example, it's okay for someone to know your name, right? Yeah. Even when that's your personal data, it's ordinary data. How it's disclosed, the regulations are not very stringent. Who knows your name and where it is published may not be very stringent. But your children's names under you, that's another category of data. But also your medical information is now sensitive data, because it's okay for me to know your name and your age, but me knowing when you last tested for tetanus, whether you were vaccinated for, hepatitis B or stuff like that. That becomes very sensitive. So even financial information falls under that sensitive umbrella. Okay. So, however, in all circumstances, where it is believed that it is necessary to know this information is accessed through legal means. Exactly. For example, let's give you an example through the criminal regime. If someone defiled a child, there is a legal requirement to actually find out if they infected this child. And sometimes this may include mandatory testing of the accused person. And that means you are accessing their sensitive information data, but through a legal regime because of a cutout need. So if you are a banker, you're a business, you bank your money somewhere, but your transactions are very suspicious. Whereas you will claim that this is your sensitive data, and actually you have a contract with the bank when you are opening up an account. A confidentiality clause is in that contract that the bank will do everything possible to keep your information confidential. But there's another clause that where there is suspicion of criminality, the bank then would have to cooperate with the criminal justice system or even with the state to ensure that justice is served to that end. And those are the, we would say, those are the exceptions to your confidentiality. Arrangement with the bank. So it's the same thing here. You have information, it is safeguarded by all these bodies. In fact, when URSB is giving information, because they'll give you your beneficial owners form, the bank is not going to ask the URSB to just give them the form. In most cases, you, the company owner, has to voluntarily take and disclose your information to the bank. That's the arrangement. So when you don't disclose, the bank will just say, well, for us, the account cannot be accessed. Because what has been set out for us is that we require this information, but you have to voluntarily give it to us. So when you give it to them, then they also know that they have a duty to protect that information from unlawful disclosure. You won't find it, that place where you just pick the deposit slips or withdraw. You won't find people's beneficial ownership forms just thrown in that place.
Interesting.
It's clearly how it must be done within the law.
All right, as we wind up, in 1 minute, Charlotte and David, let's talk about what is the working relationship, you being partners into this, in terms of enforcing this, and do we have a central coordination system to coordinate the illicit activities?
From our side, most of our works, I'll speak as an NGO. Sometimes some of our works are program-based. However, our mandate is that we have to work with the relevant government authorities to ensure that if there is something we want to push it through the existing government systems. So far, I think we are headed in the right direction.
Okay.
This conversation didn't just start yesterday. It's been on for a very long time. And where I've reached, I think we'll be getting there.
Beautiful. And of course, thanks for being part of Smart Means Business today. And the Business Insight has been proudly brought to you by Transparency International Uganda. And of course, in the discussion in relation of beneficial ownership law. And the panelists have spoken. I've been with David, Transparency International Uganda Programs Officer, and Charlotte, a Senior Registration Officer, URSP, and Blair, who joined us shortly after the first break from the law company known as KTA. Well, it's quite a cold morning, but of course that doesn't stop you from being productive, or you'll be having your public holiday celebrations. But of course, above all, set your strategies right as you're concluding the week, such that you ensure that there is no leakage in your incomes as you're running your company. Well, till tomorrow, have a good one.